And we are live. Good afternoon. My name is Mary Auld-Kovacs. Welcome to Let's Talk, Real Talk on Parent Alienation and Family Court with our two special guests. We have Mr. Gene Coleman from North York, Ontario. He is a family law lawyer. And also we have Vernon Beck. He is our repeat podder from Canada Court Watch. He's also with Family Conflict Services. He is the founder of both. And we are here to talk about the family court problems that many of us have during child custody battles and, parenting, and one parent gets the child or over the other. And, we always need to find solutions. So what better people to have than Mr. Coleman and Mr. Beck? So in opening, I want to welcome everyone that comes to Let's Talk Real Talk and to help find solutions, share your stories, all your expertise with problems with the family court system. While most know that there are an almost overwhelming number of problems with our family courts, overcoming these problems, it to identify them and to provide solutions. Today we have two special guests who are here to help all your, in your head, we don't know what to expect, but this way we have two knowledgeable people who will guide you step by step. Probably, I don't know, but I'm hoping that, we can have a good way to ease our minds on how we're going to pursue family court with our children. So introducing again, we have Mr. Coleman. Welcome, Mr. Coleman. It is a pleasure to have you here. We've been sharing a lot of info over the social media on family courts, and I've had some really amazing guests to come out, and you are one of the top that I've been hoping to get out here for years, and you did it. You made 2025 all the best for me, and to share it with Vernon Beck. I know you two got history together, so I welcome you both, Mr. Coleman. Thank you.
Thank you.
And Vernon Beck, thank you.
And thank you for inviting me on the show.
You're welcome. Pleasure to have you. So my first question is to Mr. Coleman, and is based on your experience with family court system. Can you provide an example of what you feel would be one of the most significant problems with the family court system that, in your opinion, needs to be rectified? And what practical solutions would you propose to fix this problem?
Thank you, Mary. And yes, I am going to share my views with respect to the essence of the problems with our family court system, specifically in Ontario. A lot of what I say would apply across Canada, though. So I thank you for the opportunity to share my perspectives with respect to family law and the family court system. After 45 years of experience as a family law lawyer, I firmly believe that our current approach to dispute resolution is fundamentally flawed. The adversary system, which pits two warring sides against each other, does not and never did serve the best interests of families and children, in my view. Now, various reforms have been implemented to mitigate the worst aspects of our system. And some examples are: 1, mediation; 2, parenting assessments; 3, voice of the child report; 4, parental coordinator; 5, some legislative changes, such as eliminating divisive terms such as custody and access; and various changes to the Ontario family law rules. And 6, one of my favorites, collaborative law. Now, these measures that I've just outlined, while surely helpful, I say are merely band-aids being applied to the festering wounds. They operate within the existing adversary system, which inherently rewards, aggression, sharp practice, and tactical maneuvering. The result, in my view, is a system that perpetuates conflict rather than resolving it. Report after report, including one authored by no less than a former Justice of the Supreme Court of Canada, these reports have highlighted the profound brokenness of the family court system. Yet those in charge of the system seem reluctant to think outside the box and implement meaningful reforms. Who's in charge? The Attorney General of Canada, of the province, also of the province of Ontario, and this applies across Canada, provinces and territories. The bar associations, the vested interests. In my view, as I guess folks watching this have already come to the conclusion that Gene C. Coleman does not go with the mainstream. I don't, and I'm proud of it.
Proud of you. Proud of you.
In my view, a crucial step towards meaningful reform should be the introduction of a legislated, rebuttable presumption for equal shared parenting. This would provide a starting point for dividing decision-making and parenting time. We only need require that each parent is deemed to be an adequate parent, not super dad, not super mom, just adequate. And where all factors are relatively balanced, the result should be, in first instance, equal shared parenting, where at all possible. The social science literature overwhelmingly supports the benefits of equal shared parenting for children, families, and for society as a whole. However, equal shared parenting is only the first step. We must also address the incentives that drive parents to engage in malicious behavior such as parental alienation. Recognizing parental alienation as a form of child abuse, and some cases already do, by the way, recognizing PA as a form of child abuse and implementing legal and other measures to prevent it would certainly be a significant step forward. And now I come to the most significant recommendation that I have to present here. And I am presenting this recommendation here publicly for the first time, basically. Ultimately, the most radical, I'm so conservative, the most radical and necessary reform, hear me out, folks, has to be a fundamental shift in the approach of family law lawyers and in the approach of self-repped litigants. Of course, I recognize that many people don't have a lawyer for various reasons. We need a fundamental shift. We need what's called a sea change. Rather than perpetuating conflict, lawyers and others must be incentivized to find solutions that prioritize the well-being of families and children. This requires a collaborative type approach where lawyers work together to identify the applicable legal principles to the case and then develop solutions for the fractured family. Now listen to this. This is coming now from someone who has been, and still is, where necessary, a gladiator for one's clients. But here, listen to what I'm going to say. A family law lawyer should not see him or herself as a gladiator. Rather, the ideal self-image for a family law lawyer must be a solution innovator. Where the two sides cannot come to a solution, then okay, we'll have to have a judge make the decision. But we have to work in incentives into the system for the parties, for the lawyers, for the judges to find solutions rather than create World War III. And the point I'm making here is the adversarial system, which goes back hundreds of years, not appropriate for family law. By implementing these reforms, we can create a family law system that truly serves the best interests of families and children. It is time for us to rethink our approach to dispute resolution and prioritize the well-being of those whom we are supposed to serve. Thank you.
Absolutely. Absolutely. Thank you for that. I mean, that was a lot of information. Vernon, can you see what Mr. Coleman is doing in how you help families as well? What's your outtake? Could you explain?
Well, let me comment on Gene's. Certainly, I love his presentation. I love the comments he made. Gene and I have been working probably for decades toward the idea of equal share parenting. We support it. And many of the ideas that he has talked about, some of these things they've been kind of implemented, they're there, but unfortunately the people that control these mechanisms that he's mentioned, such as collaborative law and stuff like that, these mechanisms are still being run by the people who are adversarial. So you still get those processes run in an adversarial way. Myself, I work in the area of developing tools. That's kind of been the area that I consider myself unique in. And for instance, I do work as a parenting coordinator. I do provide voice of the child reports, and I'm probably one of the few people that do video recorded voice of the child reports. But to get on to what I see as a problem, which is what the topic of the show is today, I'll take one problem that I see, or one more point about Gene's comments about there being a drastic change in the way lawyers and everybody thinks. I mean, we could go back throughout history, generations and generations and generations, and unfortunately, humans have weaknesses, whether they fight, whether it's greed, there is good, there is evil, and some of these things can never be overcome. And I believe that the systems we develop will never make these people change, such as adversarial lawyers, adversarial judges, adversarial people that are doing these things. But we have to develop the tools that will prevent them from doing what they naturally would do and rein them in. Just like if you have a wild horse, we have trained horses now to ride. We can put harnesses on them. They can pull carriages and they're not bolting off and killing people. I look at the system as that we have to find those tools, and there are probably many of them, and individually that will make a small difference. I'm going to start off with one area that certainly in my 28 years of being involved in this area of helping children and families, and that's how long Canada Watch has been around. I've been around since 1995. and so has Family Conflict Services. We have had a phone number and websites and email addresses for 28 years. And I have a library of interviews with children and parents that would literally shock most people. Let me get on to the one area that I believe is we need accountability. I believe is one of the big things. Accountability. And I used to be a member of the press. I had a press card. I was in my early years when I used to go into court. I was a journalist. I actually had a press card. I was a member of the union, and I could get in, and I used to go into courts. I still see the same problems going on in the courts today as there was 28 years ago. And let's talk about accountability. As recent as probably 2 months ago, I was in the courthouse on University Avenue, 361 University Avenue. I was asked to attend a court hearing, and I went into the court hearing at the request of one of the parties. And of course, the lawyer for the other party asked the judge that I be ordered to leave. Okay. It's a public courtroom. Okay. But we have a member, we have a lawyer who's supposed to know the law, supposed to know that the courts are public. The judge wasn't sure. The judge asked me to leave, and I had a witness with me. There was two of us. We left. So the judge could discuss this with the lawyer in the courtroom. Now, that argument cost the lawyer's client probably a few $100s. And but nobody seemed to know, not the lawyer and neither the judge, knew the Courts of Justice Act. I knew it better than them. Okay. Now the judge did grant us back in, let us back in. And I think the judge realized that it's a public courtroom. And actually the judge thanked me for coming back in, which was good. But nobody knew the Courts of Justice Act in there. And so what I've noticed when it comes to accountability, I'll give you some examples of things. That's just one example. I have been threatened with arrest by judges because one of the lawyers have said, "Get me out of the room." I have been in a courtroom where every major newspaper has been in there, and I've been centered out by, in this case, here was the Office of the Children's Lawyer, because I had spoken to the child that was involved. So I could tell you some pretty scary stories. Now, what I have found, number one, another example, I was in a court case on Shepherd Avenue. I witnessed, along with other family members, a judge commit criminal acts. She ordered police to unlawfully seize a 14-year-old child. And I know Jean knows who the judge is. She's been in the newspapers before. I've seen that judge.
Don't say her name.
I'm not going to say her name because I'll probably have the police at my door. Okay. But
Well,
anyways,
you don't want to get shut down.
I've had ceases at my door over this stuff before, so doesn't worry me. But anyways, the police committed assault. 3 police officers restrained a 14-year-old boy. We found out that he had come with the family members to tell the judge the truth, tell the judge what was going on. And unfortunately, one of the lawyers, we found out, is kind of friends with the judge. And we were threatened with arrest if the family and myself did not leave that courtroom. We were escorted by Toronto police outside the building and told we actually had to get out to the sidewalk and we would be arrested otherwise. Of course, I know about the law. I requested the transcripts. Everything was gone. I tried to find out who the police officers were. Nobody knew who they were. There was no record of the police officers being at that courthouse. There was not even a record of that court hearing that day.
Wow.
It had disappeared. So out of that and other examples I could mention is that, number one, I'm a strong advocate. We need cameras in our courtrooms.
Absolutely.
Okay. And you know that we've collected videos of people who have been threatened bullied, and I've got all kinds of interviews with people, whether it's the court, even the court secretaries have come down from the front to threaten people.
Mm-hmm.
All this will not show on the transcripts. And we all know that transcripts have been fixed in the courts. I have examples in the Milton Court. We know that the Shepherd Avenue courts had that problem, and we know the names of the judges that have done it. Cameras would bring accountability, tremendous amount. We have the cameras in there already, because even recently I have attended some virtual hearings. The judge gets to see your name on the camera. You get to see the members of the public. So we need cameras in our courtroom. It will cost next to nothing for the government to implement because the equipment is already there. You can connect in with Zoom, and these video recordings can be made available to the people probably the next day for a very minimal cost of $25 or $30. And video recordings, it's almost impossible to alter them because there's motion involved. Whereas audio recordings, I did have a court reporter at one of the courts show me how they were editing the audio recordings. They take the audio file, and you got all the little ups and downs in the audio file. Yes, you can splice it and remove it, and nobody will know where it's been cut. Video cameras make it very difficult. And I believe video cameras will also improve the accountability of even lawyers, because the lawyers are going to see you can't be putting a finger up at people. You can't be sending messages to a judge with your hands. This goes on in the time in the courts. It'll save money. And as far as the public's confidence, everyone I've spoken to, in fact, we've got a lot of signatures on a petition already, members of the public support cameras in the courtroom. It'll be supported by the public. It will save money, and it will improve the accountability of everybody in that courtroom. So that's the solution that I would propose as something that would help tremendously. And we already have signatures on a petition. And in fact, I've spoken to people who actually work in the court, and they have actually, and even at Children's Aid, they've signed the petition because they too support it. And Mary, we went down to it was actually just back in the summer, we went down to the public park in Burlington. I think it was the Rib Fest. We went around and talked anonymously to people.
That was the Labor Day weekend.
Labor Day weekend.
Yes.
And Mary was with me that time. And we went down there. We had a petition form. We had information about cameras. And we got all kinds of signatures. And one of the persons that we spoke to was a personal friend, believe it or not, of Doug Ford. And he signed that. He said, fully agree with you. In fact, that person said they do the cameras. His company does the technical for all the cameras in the Ontario courts. And he says, I agree with you. He says, we can implement it. It would be nothing for us to implement it so that the public and these video recordings can be made available. So that's one solution that I strongly I believe would be a significant impact, and one of those tools that I talk about. Now,
can I say something, Vernon?
Sure can.
What's the difference between hybrid hearing and cameras in the court? Because the Attorney General just spent $165 million worth of hybrid hearings. How is that any different than having cameras in the court?
Well, a hybrid hearing is, for instance, traditionally the court, only members of the public go in. If you want to go and see the court, you had to physically be there. The parties had to physically be there. Well, what they're talking about hybrid now, the parties can decide, and it's going on right now, the parties can decide if they want to have virtual. And, or for instance, if it is in the court and you have a witness that happens to be out in British Columbia, and who knows something about the case, the judge could have that person come in and be part of the hearing. So it's part virtual, and yet you have people actually sitting in the courtroom. So I believe that's what he's referring to as hybrid. But a lot of these hearings are going over to Zoom, and there's great advantages to that, and
It's cheap.
great cost savings, and to the parties. Everybody that goes downtown Toronto or to Shepherd Avenue Court, you got to pay a $20 to park your car. Plus, by the time you get there, for the average person to go down to the courthouse, for instance, the lawyer is going to charge maybe 3 to 4 hours. Prepare, drive down, park, walk upstairs, sit in the waiting room, and you can significantly cut the cost to the parties in court by thousands of dollars.
Mhm. Yeah, that's so true.
Gene has a question.
Mary, Vern, I do have comments on Vern's accountability suggestions.
Yes, I was going to ask you.
Shall we wait to the end of Vern's solutions, or shall I respond now?
You could respond now, and then we can go back and forth. That's no problem. That way, that we could register everything that's going on, because this is a lot of information.
Whatever you guys say. Okay.
Yes, accountability. It's very important.
I don't normally eat when I'm on a webinar, but I'm very blessed to have my second oldest son and his 4 kids living with us while they're doing renovations in their house. So my little granddaughter brought me down some food here that she and her sisters made. So
How sweet.
eat a little bit of it.
Grandparents are important, and we're losing a lot of grandparents too.
Are important.
Yeah.
But let me talk now
Yes.
about accountability. And Vern called it one solution. And I believe I share Vern's concern that we need greater accountability within the system. We need accountability by judges. We need accountability by lawyers. We need accountability by institutional litigants such as children's aid societies, Office of the Children's Lawyer. Of course, it's very difficult when we all agree on the concept of accountability, but implementing it is another matter.
Right.
Because the standards of accountability is that as per Vernon Beck, as per Gene Coleman, as per Mary Auld-Kovacs, as per Joe Blow in the street, like who sets the standards for accountability? Of course, about Vern being threatened with arrest on the occasion of with that judge whose name will go mentioned about the police restraining a 14-year-old. I was simply trying to tell the judge what his preferences were, and there's lots of law stating that with the older the child is and the more mature the child is, the more weight we have to pay, we have to place on child's preferences. But that particular hearing, the goal seemed to be to that 14-year-old from even opening his mouth.
Mm.
So I know, like, there's all sorts of terrible things happening. So Vern then tells the story. He says, well, one way we can solve this by putting cameras. And he pointed out that he knows someone that had the contract to put the cameras in. This was a COVID-inspired reform. Some hearings are held remotely with everyone participating by Zoom. Some are held partially remotely. Some are in the courtroom. Some are remote. And given that courtrooms are public, as Vern correctly pointed out, as per the Courts of Justice Act, then everyone with the link, anyone should be able to get the link. And just as if you go down to courtroom 301 at 47 Shepherd, I can't forget the number, Shepherd and Young, you should be able to tune in and
Mhm.
what goes on in the system. And there should be no legal impediment to that. But I must, well, my heart is with Vern's recommendation. My brain tells me otherwise. You might be surprised, Vern, but let me express my caution here. I believe in open courtrooms, but making court proceedings readily available over the internet, family court proceedings, where there are many things that the parties would like to keep private, where we are talking about children who the next day are going to go to school and be potentially teased by their classmates. Oh, your dad's a real this. Oh, your mom's a real. Oh, I saw it on the internet. I don't want to expose kids to that. And I don't want to expose my clients, and I say that sort of generically, one's clients, to public shame and ridicule. Our system, the way it's structured, shames people enough already, even without all sorts of spectators being in the courtroom. When they have a legal right to be there, I'm not going to change that. But I don't want to make it totally easy for people just sort of to tune in to the 47 Shepherd Avenue courthouse or the 361 University courthouse on there and watch the cases and that record it, post it on other websites. It's too much an invasion of privacy. Even though there's no legitimate expectation of privacy because you're in a public courtroom. Child protection proceedings, that's something else. But just talking general family law cases. As you can see, Vern, Mary, I have
Okay, let me respond to.
a lot of reservations. They are privacy concerns, and I don't want to expose parents and their children to this. Okay, Vern, what do you say, my friend?
Okay, to answer your concerns, what I have would propose and what I've visualized is that the cameras in the courtroom would be just like a court reporter would do. That camera would be those cameras, those video recordings would be available only to the parties, only to the parties. Just like right now, you can get the audio recordings, but you can get the video recordings, say the next day or the following day. And people would sign an undertaking to understand that that is to supplement, and they are not, just as we have in the Courts of Justice Act on recordings under sections 136 2B, is that it's there for the purpose of supplementing your notes, and you cannot publish those. And you could probably even put a fairly significant fine on that undertaking. People would have to sign, understanding that they could have a $10,000 fine should they publish those recordings. But they would be able to have a copy of that recording, just like they do right now of the audio recording, for $25. But the recordings on video are going to be much more reliable, and they're going to catch any physical movement in the court. If people are threatening, making hand gestures, things like that. So that's what I visualized. Now, you were in what you were talking about is people having access to the courtroom through the internet. I would agree with you there as well. And I would say that that people from members who are members of the public who could give a justifiable reason for attendance. I was in a virtual courtroom. I think it was out in London just about a month and a half ago. I was given the link. I was able to get in there. It was a family court hearing. It was pretty controversial. There were no conditions put on me. But as I was there, I could see there were law students logging in and logging off, because in front of the judge, there was a big TV screen, so the judge could see who's coming on. And of course, before I went into the hearing virtually, I had to explain to the receptionist there who was handling the Zoom call. I had to explain who I was, identify myself, and to give my reason for being there. So yes, I had to identify my name. I had to give a reason for being there, and that I knew one of the parties there. So that should be reasonable grounds. So it's not so much general members of the public having access to the virtual just on the internet, but certainly you may have grandparents that live 3 hours away. They can't physically go there to support, but they should be able to go to the make an inquiry at the court, and that secretary who's managing the Zoom should know that they're expecting these family members. They're from Alberta. They would like to watch what's happening with their son's hearing in Toronto. That's what I'm proposing when it comes to cameras in the courts, is that just like the transcripts are strictly cameras, but you'll get the video. And again, people will sign a disclosure and an undertaking that there's going to be heavy fines should they publish that information. Plain and simple as that. So you can still take that camera, you can still take that recording. You could take it back to your lawyer. For instance, if you're self-represented and had an unbundled services lawyer, you didn't have to spend $3,000 for them to come to the court, but you could take that video recording. You could go and sit down with the lawyer outside the court, and could you please comment on how I did as a self-represented rep in that courtroom? And that's where a lawyer would be able to still provide help to people based on that recording. And of course, if there is anything that went on in that was, I mean, yes, there are some violent things that go on in these courtrooms. That's going to catch it.
Right.
Where
Well,
audio will not.
let
Okay.
me say something on behalf of a litigant going through the family court system, why it's important to have cameras, and especially you are so overwhelmed by being in the courtrooms that you're scared, you're terrified, you're not listening to everything that's happening. And as an alienated parent who hasn't seen their child, they're going to be very emotional. So to have cameras in the court, or even have someone take notes, have a voice recording or something there so you could take notes. Like you said, you want to take it to your lawyer, or if you even have a lawyer. Sometimes lawyers miss out on a lot of important details because they don't know your life. You know your life. You know what's going on in the courtrooms yourself, but you can't interrupt anybody. It's only limited. Our time in court is limited to what, 30 minutes per case? So in 30 minutes, your brains are just like scattering everything. So it's important. And, you know, a lot of us with disabilities, head traumas. I mean, I want to ask Mr. Coleman all this question too on people with disabilities and people who are suffering after years and years of being in the family courtroom. You must see that a lot. You know, some people take 10 years, 18 years in my case to never see their kids. You know, it wears you down. What do people do about that? You know, because that's court abuse to keep being dragged into the system over and over. And, you know, we're paying to see our kids, but we don't get to see the kid. There's so many things that we need to
Well, you're not paying to see your kids. Child support is an independent right of the child to be supported.
Well, I'm talking about supervised visits. A lot of people.
Supervised visits where you are retaining a private service.
Yeah, to see your kids.
Just side by side, or any of the other ones. Yes, in some special circumstances that does take place. But I think where we are going now is more into micro issues, and that's not with Vern's, for example, with Vern's explanation of how his accountability with videos would work with the caveats he placed, he has addressed some of the concerns I have. But even there, I would suggest that we get back to the title of this program, which is problems with the family court system and the solutions. And while, yes, we're talking about problems here, I have approached it more from a very macro high, not micro, but macro high level problem with the very nature of the adversarial system. And I have proposed legislative reforms, i.e. rebuttable presumption equal share parenting. Of course, here in this program is not the first time I've said that. But I have said in this program for the first time, we need a fundamental shift in the approach of family law lawyers and self-reps to how we approach this system. And we need changes coming from up above. I want to see a wholesale change in the system as opposed to, as I mentioned in my talk, Band-Aid solutions. Band-Aid solutions are fine. I mean, changes in legislation, changes in the rules, Vern's suggestion here about accountability through video recordings with control so it doesn't appear on the internet the next day. Yeah, these are all good. I don't want to minimize them. But I wonder if we could redirect the conversation back to what do you guys think about lobbying governments to change family law? Like, this is a huge change. Oh, Coleman wants to abolish the adversarial system. What did he have for breakfast this morning? No, I want to change the entire system largely do away with the adversarial system, because I have experience as a advocate since second year law school, even more than 45 years as a lawyer, since second year law school, doing family law cases, the damage the adversary system does to people.
Right.
And I agree. I too agree with.
Vernon's been like, we've been advocating with letters to constituents and all that. And Vernon's been doing such a wonderful job writing letters to, Premier Ford. We had the Attorney General on, and we're not getting very far, but we need stronger people.
Well, to continue on where, basically what Gene's looking at an overall approach, and I guess I certainly agree with him, but I take an approach that to change the big picture, it's going to take small steps, okay, just like when they stepped on the moon. One small step for, yeah.
Vern, I'm not opposed to those small steps, but the small steps are just Band-Aids. Good Band-Aids, if you got a cut and you put a Band-Aid on it, that helps. But it doesn't change the overall damage and injury.
What I would...
The adversarial system has to go. Now, some parents choose collaborative law. And in collaborative law, everyone signs on that they're committed to reach a deal. And if they don't reach a deal, they have to fire their lawyers and go to other lawyers to take it to court. So you have a huge incentive to stick with collaborative and make a deal that is not only in your own best interest, but in the best interest of your children. That's great, but collaborative law is not compulsory. So
let me give you...
We have to change the system. And if you start by major legislation, i.e. rebuttable presumption equals shared parenting, you want to take the conflict out of the system.
Right away.
And by rebuttable presumption of equal share parenting, which we here on this Zoom presentation, almost not Zoom, whatever the platform is, but this video presentation have been involved in and have been struggling for, and to have effective means of combating parental alienation. Like, these are major parts of the system. When you've got an adversary, let me try parental alienation into the adversary system. The adversary system pits two sides against each other to come out on top. I'm a better parent than you are. The kids love me more than you. Sort of like a skit from Smothers Brothers, a TV show from the 70s or 80s.
Yeah.
Mom liked you better, or mom liked me better. That's what you have. We shouldn't have to prove that mom is better than dad or dad is better than mom. And when the system is forcing you to do that, That is part, not the only, but part of the reason that parental alienation is such a big problem. You feel, I don't want to lose my kids. I better get the kids on my side. Oh, your mother did these terrible things. Oh, you should see what your mother did when you were 2 years old. Oh, it's horrible. And you get kids talking about the terrible things their mother did them, and the father has implanted those
Mhm.
false memories in the kids. So, like, you are incentive. The adversarial system incentivizes parental alienation.
Absolutely.
Okay, if the starting point is not going to be every second weekend, a bit of the holidays, but the starting point is going to be 50-50, that's what we're going to assume is best for kids, because the social science literature tells us it's better for kids. Then where's the incentive?
That's right. I've been
And
saying that all along.
as part of that, as George Piscor, who many of us know, will tell you, you got to change the child support guidelines. Quebec did it, but the other provinces and territories have not, so that there's an incentive to limit dad to no more, or mom as the case may be, but dad to 39% of the time, because once he's got 40% of the time, which is 40-60, approximately equal, oh well, now we're going to change how we calculate child support. So mom says, oh, he only wants 40, 45, 50% of the time because he wants to pay less money.
Right.
And so, like really strange. Whereas the focus of our family law system has to be, well, what is best for kids? Well, social science research tells us that approximately 50-50 is best for kids. That has to be the starting point, not the other. De-incentivize conflict. I want to go for the max. So, I mean, we've had, and I know Vern, Mary, you guys have supported the efforts that I've made, and George Piscor made, and many others have been made. And Brian Ludmer, my dear colleague, a family law lawyer, you supported that, and we tried. And then Brian and I went Brian went there personally, and I went virtually, and made presentations to the Justice Committee when they were considering bills. Was it C whatever number?
16, 14?
No, it was for 3 digits or for 2 digits.
Oh.
But anyway, the one which resulted in our current version of the Divorce Act that got rid of custody and access and put in the other terms. So we've been working, literally, Brian and I and George and many others have been working literally decades on this, and most of our colleagues in the bar have opposed. I wonder why. Like, why would you oppose something if it's good for kids? I didn't write the social science literature. Many greater minds than mine, like Professor Kruk and Professor Nielsen and Dr. Warshak and others, have done really serious empirical research and have proven it beyond a doubt. So it's a no-brainer. It's a no-brainer. In Kentucky, when they made the changes, first for temporary orders and then for final orders, they brought it in the following year and a half later, rebuttable presumptive share parenting, every single member of the legislature that voted for equal shared parent in Kentucky got reelected. And every single candidate or representative that was candidate for reelection that voted against got turfed out. Hey, it's a political win. It's a societal win. We've got to hit these macro issues, the big issues.
And I agree that that's part of the battle, Gene. Yes, we need people who are going to fight at the macro level, such as you do and other high profile people. But again, I'm always saying that even in the background, when you're solving some of the things such as the accountability in the courts and the violation to people's rights in the courtrooms, that has an effect as well. And again,
it does. I'll grant you that, Vern. It does. But boy, I'd love to see you and Court Watch and others like you guys more approach the macro issues, joined the Equal Shared Parenting Working Group, which has representatives of a number of organizations on it, such as Paulette McDonald, who's a legend in the work that she's done.
Well,
And
Gene,
other
I did testify before the Federal Joint House and Commons Committee back in 1998. I was one of the presenters. And I was one of the key organizers in that whole effort years ago. I presented to
that report, for the sake of the children, laid the groundwork. That report from Senator Cools and
Roger Galloway
and Mr. Galloway,
yeah.
Galloway.
Yeah.
That for the first time talked about, let's take custody and access out of the legislation. It took a couple decades for the government to do it, and it took actually a liberal government to do it, where it should have been the conservatives earlier, because equal shared parenting, not that the legislation changes made equal shared parenting, but using the terminology was a step in the right direction. The conservatives under Harper should have put that in earlier.
Yeah.
But
anyways, it was
earlier. It was the conservative party platform.
Yeah. And it wasn't successful. I was one of the
I talked to Prime Minister Harper about that when he wasn't Prime Minister. He was retired. I met him at a conference. You can see the picture of him and I smiling on my webpage. My webpage is there, is on the screen. Go to the photo section. You'll see.
Yeah, I've seen it.
Nice picture of Harper and I.
Yes.
I asked him, why didn't you follow your party's policy? Why did you oppose MP Valancourt? Why did you oppose his private member's bill to make a rebuttable for some people share parenting? And he laughed. And he said, well, I don't remember, but I must have had a good reason. And we laughed.
No, there was probably some political influence by probably people in the industry.
Yes, there was. And the advisors that the government has in the Justice Department, lawyers in the Justice Department, and I know, were uniformly opposed to the private members bill from Harper's own party. So, we've come close at times, and then at the most recent one, considering the current bill that became the current Divorce Act, that brought in a number of really good reforms, and I write about this on my website, a number of places, that many of the reforms were very good. But when we were Brian and I were giving our presentations, and seemingly well received, everyone was talking about equal shared parenting. They were all talking about it. It wasn't in the draft bill that the government put forward, but that's what everyone was talking about. And that's what the Canadian Bar Association went in and said, don't do it, don't do it, don't listen to Coleman, don't listen to Lumber. And the other organizations and the radical feminist groups are going in. Everyone was talking about it. Well, they protest too much, and they're all nervous because a rebuttable presumption of equal shared parenting is going to change the power balance. It's going to lawyers and judges.
Yeah. And let me add, a lot of people will not be making as much money.
Oh, yes.
Well, 19 years ago, I went into court. I said, equal shared parenting, that's all I want. He could have whatever he wants. I just want my children for 2 weeks out of the month. And I got 0. And, to bring that up in court today, you almost get punished when you ask for equal shared parenting.
You don't. You don't.
You don't?
Getting back to some of the solutions here.
If you bring it up, you don't get punished. We should stay away from individual cases, even your own, Mary, because every case turns on its own facts in the current adversarial system. And there's various factors that go into decisions. And if you were self-rep, let's be gentle. If someone is self-repped, what I often say, a self-repped family law litigant is like a deer standing on the middle of the highway, looking up at
Wonderful.
the truck with its bright lights bearing down on it, and is frozen from fear and confusion. That's what the family law system is for a self-rep. You do need, unfortunately, you do. I mean, fortunately for me in my pocketbook, but unfortunately for society, you need a lawyer. You need a lawyer to stand up for you. I'm saying the way that we lawyers stand up for our clients has to be different because the adversarial system forces everyone to fight.
Yes.
You know, on that point, remember Justice Harvey Brownstone, Vern?
Certainly do. I've been in his courts rooms before. Yeah.
Yeah, he held court at Young and Shepherd. He wrote a book that was very popular. I forget the name of it, but he wrote a book on family law and his many years of experience on the bench. What people forget is, by the way, he was head of the he was the chief lawyer and head of the Family Support Plan. That's what's now called the Family Responsibility Office. He was the head of that, and then he got elevated to the bench and he had many cases. And the theme of his book was that parents are bad because they fight with each other.
Mm-hmm.
As much as he talked to them and told them to focus on the children's best interest, good message, focus on the children's best interest. We don't want to do what's right for you. We want to do what's right for your kids. These are all good messages. But he still blamed the parents. And that, I think, with all due respect to former Justice Brownstone, that was the incorrect approach. It's the system, the adversarial system, that pits the two sides against each other and incentivizes them
To fight.
to behave the way they do. Change the legislation, change the rules, incentivize lawyers and judges and the parties themselves to find solutions. You know, why does mediation work so well with many couples? Why? A mediator can't force a solution on you, but everyone wants to be heard. All they do is want to be heard. And once they're heard, they feel a lot better. Okay, so the ultimate solution that you craft in mediation may not be exactly what you want, but you make some compromise. There's some compromises. You have a trained mediator to help you. Mediation is wonderful. I'm so grateful that I went through mediation with Dr. Howard Irving and Dr. Barbara Landau. This is back in the 80s, 90s. And I really learned a lot from that, and how it's a very healthy way of bringing people together. But you can't, although mediation is spoken about in the Ontario Children's Law Reform Act, you can't force anyone into mediation in Ontario, at least.
Let me try to get another suggestion as far as a solution goes. I know James talks a lot about shared parenting, and I fully support you, Gene, in that effort. Yes, that will help. But let me move on to just another out of my hat of suggestions.
Okay, just let me tell you that we're 58 minutes in, so I don't want to keep you too long.
Okay.
We can keep going.
1 minute for me to respond.
Okay.
You can keep going. We can keep going, but I just want you to know we're heading to the hour.
And again, I've got no problem as far as time goes, but another simple solution. Good. Lawyers go into, they get cases, they go in and they appear before a judge. One of the first things that I believe should be mandatory, and judges can order this, is that parents should be ordered before they can attend litigation, before their first motion, that they must attend a mandatory parenting education program.
It is the law. That's the law now.
No, it's not. They talk about
information.
No, you're wrong, Gene. They talk about you have to take the court. There's kind of a court education program that you take, and they take you down there for just a few, maybe 2 or 3 hours, and you're giving instructions about how the court works, how to submit papers, and they tell you how to get legal aid. No, I'm talking about.
Doesn't the MIP talk about alternative dispute resolution mechanisms as well?
but there's nothing ordered. I'm
Supposed
saying
to.
when someone when a case is applied to court, rather than just this court familiarization course that you take for 2 or 3 hours, that people have to attend a parenting after divorce workshop that actually will teach parents about the harm being done to children, getting
Yes,
into the
I agree. Yes, okay.
that should be
Yes,
mandatory.
yes.
Education. Yes.
Yeah, what they're doing now is they're making people go to this introductory course, but it tells you how to get a lawyer, how to get legal aid, how to fill this form out, we need mandatory that before you can appear before a judge in an actual hearing, you must attend a parenting education program, and there must be specific items that are part of that program, such as the harm to children due to high conflict.
Yes.
That should be one of the cases. How to do, for instance, how to do a separation agreement. I know in the workshop we have one of the components is how to do a separation and parenting plan agreement without a lawyer and without going to court. Because you should know, Gene, that if you have a very good and well prepared, and I do them, a well prepared separation and parenting plan in accordance to the AFCC guidelines, and you can demonstrate that they're in accordance with guidelines, and those witnesses, there's the parties sign and there are witnesses, we all know that that becomes a domestic contract, and that is just as enforceable as a court order. And it actually has a lot of advantages, because if you need to change your domestic contract, all you need is a clause in that domestic contract that states both parties can change anything in this contract upon mutual written consent. Whereas if you have a court order made where you've spent thousands of dollars to take it to court, and you want to make a change because the kids are now 2 years older, you now have to go back to court again.
You can do it on consent. You can do it.
But again, you have to file papers to make a change. Generally, most people want to go through that.
You do, but Vern.
Yeah, but you can have an agreement. You can have an agreement that's a domestic contract, and you don't even have to go to court.
As
So,
long as they're in the
getting back to the point I said, making parents take a parenting education program.
I agree.
That should be mandatory.
That is a great idea. I agree that could be legislated, and I think that is a great idea. But just if I could say, a parenting plan put together in accordance with the AFCC Ontario guidelines, great idea. I much prefer people have legal advice before signing it, but whatever, it's signed and witnessed. It's a valid domestic contract, though that is correct. But in order to deal with a situation where one side or the other decides not to obey the terms that they've agreed to and sign on, I prefer that there be an order in place.
Well, let me answer to that one. So let me give you an example. Let's say we have a domestic contract.
A consent order, Vern, but an order in place, because if you go to the police with your signed parenting plan, and
They can't deny.
in the rare case that you need police assistance, the police will say, go see a lawyer, go to court. And so you're starting all over again.
Well, I would disagree with you on police assistance to the first place, because we should never have police go in to enforce an order involving children. That's number one. But let me explain to my experience.
But you sometimes need it.
Yeah, let me just explain then about if you have a domestic contract and you have a court order on consent. You have two documents, basically the same, but one's got a judge's signature on it. If a party disobeys the consent order that a judge signed, what's going to happen? Because unless there's actual police written in there, okay, which I see no reason for police to enforce anything, okay, especially with children. You can't have the police go and take children out of one house. That's just a form of abuse. But if a consent order is broken, the party has to go to court to get, for instance, that court order enforced. That's where the police would come in. You have to go and get a contempt of court. Okay, Now,
Not contempt. Contempt's not a good remedy in Ontario. The contempt is last
it's
resort.
it,
A lot of cases say contempt is last resort. There are all sorts of rules and sub rules in the Ontario Family Rules that enable you to get that order obeyed.
okay, but the bottom line is what the party has to go to court to get it
Yeah.
enforced. Okay.
Yeah.
Now you have a domestic contract. You haven't been to court yet. Okay. You've got an agreement witnessed. If one party breaks that agreement, it may be a slightly different paperwork process, but all you're doing is going to the court and again asking for enforcement of that domestic contract. In fact, I believe on Canley just recently, probably within the last month or so, there is a case law, I can't quote it right now, where I believe it was the appeal court decided that a domestic contract was just as enforceable. And because one party tried to change it, they wanted to change it later on. They said no, that the contract that was there was fair, it was appropriate for the circumstances, and there is no reason to change it, even though the other party claimed, well, it was never made into an order. And I just saw that not that long ago came through, and it might have been on Stanley or it might have been on the AFCC.
Vern, the existence of a parenting plan or domestic contract, if you will, is a strong factor in consideration of what a court should do or not do. And that's all that case seems to say from your summary. I don't recall the case.
Yeah. If the two parents agree and do a parenting plan, it'll stop conflict because you're walking into the courtroom. You've got it already set out. The kids are going to do this, this, and this with each parent. And, that is the most incredible thing two people can do is think about the child in the divorce, not themselves. Two adults, fighting, let them fight on their own, but don't involve the children. And equal share parenting is the only way to do it.
And that's where they learn about that, is by attending a parenting education program before it comes to that, because they're going to learn of the damage and the harm that it's going to do to their children and to their pocketbooks.
Absolutely.
If they don't get a good parenting plan done before they even, whether it's to go to court or before they even sign an agreement, they already know their parenting plan is comprehensive and complete.
Absolutely.
And a parenting plan is one of the key components that will do that. That's why in the program we use the AFCC parenting plan and guide as a template. Okay. We have more even in addition to that, because even the AFCC guidelines don't cover a lot of things that people still run into. So the idea is you teach people. I've had cases recently where we actually have a parenting plan before the person, even though they can't agree to it, one of the parents has a parenting plan already to go into court to show the judge, this is what I'm proposing. I'm asking an order based on these things. And we even get family members to review the parenting plan. And we actually have endorsement forms for members of the family to sign. So when they go into the court, the judge already sees that even though the grandparents from Alberta aren't here, the grandparents have reviewed that parenting plan, and it includes them in the summer. The kids are going to visit the kids in the summertime out in Alberta. The judge already knows, even though the people aren't in that courtroom, the judge already can see that the family members have taken the time and the interest to read that plan, to read what's in the interest of the judge, and actually to endorse it. And it's kind of like having witnesses and members of the public sitting in the courtroom. They can't physically get there, but they have witnessed and they could have actually sworn endorsement forms of that parenting plan.
Right. Maybe we could send our parenting plan to Mr. Coleman and he could view it for us, because, Vernon's always revising it. And
you want to have a workshop on it one day, Wendy?
yes, we want to have a workshop because us advocates are strongly on parenting plan, because it's the only way a judge is going to know what that child is capable of doing and what that child needs to continue to do, right? I mean,
In
you
fact,
can't.
Mr. Coleman will be the first one to sign up, right?
Well, let's hope so. You know, we got Brian Ludmer in line too, and Dr. Jennifer Harmon. I mean, we've had so many people out here to share the shared parenting ideas, because that's
We're,
what it's going to take to have healthy minded children, to
yeah,
have
I've
both
got a couple
parents.
students actually in university. We're training them right now how to do the parenting plan. So we're going over with them with the templates. We have our own guide that goes through how to go through the various components. And we've got things that go far beyond even what the AFCC has. We have an analysis sheet. And one of the things that we have created from Family Conflict Services is we have a parenting plan assessment program, protocol that has about 71 criteria as part of a checklist to review how good a parenting plan is. So we can actually go down through a parenting plan, look at each paragraph, see if this satisfies one of the criteria of a good parenting plan. And there's actually an assessment process that we actually have. And I believe the AFCC actually is having something similar done to that, but it's $400 a head to attend that workshop. And we've already got one developed.
Yeah, and I proofread them all the time for people. So, you know, like Vernon's got us working hard to help people. And it's
We'll send
important.
you out a parenting plan, Gene, that we've done. I think you'll be quite impressed. They're very visual, and we even break it down to, in our parenting plans, on our statistics, because we attach a separate statistics. We even break down on our parenting plans in the statistics page how many dinners, family dinners, that the child will have with each family. Because as we all know, family dinners are an important part of building relationships with your parents, with your family, your siblings, and what have you.
And
So
routine
yeah,
as well.
that's always been a part of a family.
Yes.
And when you get into exchanges where kids are being exchanged at, say, 7 o'clock at night or whatever, one parent has that opportunity to have that family dinner with that child. Now, if you start adding that up over a 2-week period, you can start to see one parent's getting 90%, okay, and the other parent's only getting 10% of family dinners. Well, that's going to affect the relationship that children have with their families. We even break that down in our parenting plan statistics. So we got some unique stuff we've developed as
exciting stuff, Vern. You've always got something else up your sleeve, and I'm always pleased to review your drafts. Yeah. Anyway, folks, this is about past my time. I allocated an hour for this. And
thank you so much, Mr. Coleman. Thank you for everything you put out here for us, and Vernon Beck as well, to have both of you agree on so many important facts here, legislation, equal share parenting, and all that. Thank you. Thank you. And any last words before you go?
I think it's already. Thank you.
Okay. So, alienated parents out there, remember, if you're going through family court, you need help, you can always contact Vernon Beck. We got Mr. Coleman here. I mean, we've got so many resources for you, and everybody has solutions. We're not going to steer you wrong. So thank you, Vernon and Mr. Coleman. Thank you for everything that you have done on Let's Talk, Real Talk, and we hope to have you back maybe for another session on parenting plans. Thank you.
Take care. Bye-bye.
Okay, thank you, Mary.
Bye. You're welcome.